This training is for management and supervisors of employees. Please make sure you have completed the workplace environment protection training. As an employee yourself, you learn from the protection training what legal discrimination and harassment is and is not, how to respond to such behavior, what are the consequences for such behavior. Now as a supervisor, you will understand obligations to investigate, personal liability, company liability. As a manager or supervisor, you are charged with protecting the workplace environment. Your efforts to understand, investigate, and respond to employee concerns promotes workplace satisfaction, improves the workplace overall by rooting out and correcting problems as they arise. Supervisors are often the first to learn about workplace concerns that arise from a level of unlawful discrimination, harassment, and violence. This training will assist all supervisors to respond effectively and to promote consistency in responses. The company can be held liable if the supervisor observed or learned of harassment but do nothing about it, regardless of whatever the employee in question complains. Take steps to eliminate harassment in the workplace. For example, do not let inappropriate activity go unchecked, or tactfully approve of inappropriate behavior. Be a model of good behavior and decline to participate in any harassing behaviors. For example, do not join in on jokes that may be offensive. Number 3. Make smart and professional decisions in social settings. For example, refrain from making suggestive comments or flirting with more junior employees. Support the company in its responsibilities to investigate. Refrain from retaliating against any employee who reports harassment. As a supervisor, your actions can put the company on the hook for liability if an employee can show that you knew or should have known, which we will call notice, about the unlawful behavior. It is not necessary that the employee turns in an official complaint. In fact, all that is needed is evidence to meet the legal standard of notice about the unlawful behavior. This means that if an employee shares with you in confidence that he or she heard that an accused employee made inappropriate comments to another employee, then you are on the hook for having notice about potential unlawful behavior. You are now required to investigate, even though no official complaint was filed by the employee. If you do nothing, then you put the company and yourself at risk for liability. The following are necessary steps to protect the company if a lawsuit is filed. Document all compliance activities. Record dates of all resources retained. Be clear in communicating that the company takes notice of unlawful behavior seriously. Documents to retain include employer prevention efforts, including policies, acknowledgments and training, employee complaints, investigation files, and employer responses to complaints. Investigate internal complaints are noticed promptly. A prompt response to an unlawful behavior complaint or notice of such behavior is essential to a successful legal defense. Be candid with the parties and witnesses. Complaints and interviews are not confidential. Due to the nature of gathering information, perform an investigation. A prompt investigation and response can reduce the risk of litigation. Clearly identify both the problem and an appropriate solution. Whether he or she actually files a complaint, promptly interview the complaining employee. 2. Confirm the nature of the alleged conduct and the identity of the potential witnesses. Make the complaining employees aware that the complaint has been taken seriously. Document the complaining employee's accusations in writing, and have the employee confirm to the completeness and accuracy of the accusations at the end of the interview to avoid later changes to the employee's account of events. Never force a confrontation between complaining employees and the accused employee. When interviewing a potential witness to the alleged unlawful behavior, employers should A. Gather information from the witness that either supports or challenges the complaining employee's allegations, and maintain witness interview materials in an investigation file. When interviewing the accused employee, employers should request that the accused employee respond to the allegations. Include a management witness in all discussions with the accused employee. Employers should document every element of the unlawful behavior investigation in a clear, legible, and accurate fashion. Maintain all related materials in an investigation file, separate from personal records. Following the witness interviews, employers should review all the information received from the interviews, re-interview the complaining employee and the witnesses if necessary. Prepare a detailed investigation report summarizing the investigation findings and all relevant dates. Maintain the investigation report in an investigation file separate from personal records. If harassment is not confirmed, follow up with the individuals named in the investigation. Inform them that the allegations have not been confirmed. Remind employees in writing that they must comply with employer policies prohibiting the unlawful behavior of discrimination, harassment, and retaliation. Remind the employees named in the investigation that allegations of the unlawful behavior of discrimination, harassment, and retaliation are taken seriously, and provide the employees with a copy of the written policies. Employers, supervisors, should also consider reminding employees that retaliation against the complaining employee or any witnesses is prohibited. Consider proactive measures to reduce future risk. When the allegations have been neither confirmed nor disproved, consider taking steps to reduce the risk of future incidents. Any proactive measures should be voluntary for the employees so that they are not mistaken for retaliation against the complaining employee or discipline of the alleged wrongdoer. For example, consider giving the employee the option to switch their shifts or work locations where practical, changing the reporting structure if the complaining employee reports directly to the accused wrongdoer if possible. If harassment is confirmed, access options for employer response. Determine the range of available corrective measures. Seek advice from legal counsel. Impose appropriate discipline. Select a disciplinary response, including potential termination of the alleged wrongdoer's employment that will effectively end the harassment. Provide a reasonable response that takes into consideration both the nature and severity of the conduct and any previous violations. For example, greater penalties for repeat offenses. Document all disciplinary and corrective measures. Follow up with the complaining employee. Inform the employee that the allegations have been investigated, a conclusion has been reached, and, if appropriate, action has been taken. Explain to the complaining employee how the action has remedied the problem. Let the complaining employee know that the complaint was welcome. Thank the employee for coming forward and advise that any future incidents of perceived unlawful behavior or retaliation should be reported immediately. At the end of the employment relationship, obtain waivers and releases from employees who present a litigation risk. For employees who may bring claims against the employer on grounds of unlawful behavior, employers can insulate themselves against litigation risks by asking departing employees to sign a waiver and release of claims in exchange for sufficient consideration. Analyze termination decisions to ensure there is no quid pro quo harassment. For example, ensure that no employee is being terminated because he or she refused to submit to sexual advances. Document termination and layoff decisions. Employers facing litigation alleging unlawful behavior may be required to disclose relevant documents in discovery. Always document the legitimate business reasons for termination and layoff decisions concerning each affected employee. Employers that treat departing employees with respect reduce the risk that those employees will file legal complaints. Sexual harassment, discrimination, and violence are inexcusable actions that will not be tolerated. Your role as a supervisor is serious in protecting the workplace environment. Continue asking questions so you are prepared to handle yourself appropriately when you are put on notice of unlawful behavior in the workplace.